Most Virginians use the words cannabis and marijuana interchangeably, but under Virginia law, those words do not always mean the same thing. And in certain legal situations, that difference can matter more than people realize. Here's the context. Today we're breaking down cannabis versus marijuana in Virginia law, why both terms still exist in statutes, how courts and regulators use them, and what this means for residents, businesses, and compliance professionals across the Commonwealth, especially here in Norfolk and Hampton Roads. This is an educational, legal analysis only, not advice or advocacy. Here's the legal background. Historically, Virginia law, like federal law, used the term marijuana. That language traces back decades and still appears in older criminal statutes, enforcement language, and some court opinions. More recently, Virginia lawmakers began using the term cannabis in newer legislation, particularly when discussing medical cannabis, regulatory frameworks, and adult use policy discussions. This has created a dual terminology system inside Virginia law. Here's the key legal distinctions. In Virginia statutes today, marijuana often appears in criminal enforcement and legacy code sections. Cannabis is more commonly used in medical, regulatory, and policy-forward language. Importantly, this does not mean marijuana and cannabis are treated as different substances, but it does affect how laws are interpreted, enforced, and updated. Who this affects? This terminology issue affects Virginia residents trying to understand their legal exposure, medical cannabis patients reading compliance rules, attorneys interpreting statutes, local governments drafting zoning or enforcement policies, judges applying older code language to newer laws. Misunderstanding the language can lead to confusion about rights, restrictions, and enforcement risk. Local enforcement implications. In places like Norfolk and the broader Hampton Roads area, enforcement decisions often rely on the specific wording of state statutes, Attorney General guidance, local ordinances referencing older or newer terminology. That's why language consistency, or inconsistency, can influence how laws are applied on the ground. Why this matters. Legal language shapes outcomes. When statutes aren't updated uniformly, it can create public confusion, complicate compliance, lead to uneven enforcement, slow regulatory clarity. Understanding terminology is one of the most overlooked, but most important, parts of staying informed under Virginia cannabis law. What to watch next, legally framed. If you want a deeper breakdown, we've published a full written legal analysis on our website and opened a community discussion where Virginia residents are comparing how these terms show up in real-world enforcement. You can read the full article and join the discussion inside the Norfolk City Cannabis Community, where conversations stay factual, respectful, and Virginia-focused. Please like, comment, and subscribe for more Virginia cannabis law explanations like this. And I'll leave you with this question. Do you think Virginia should fully standardize its cannabis terminology, or does the distinction still serve a legal purpose?